Everyone. My name is Przemysław Walasek. I'm partner at Warsaw office of the law firm TaylorWessing. I'm responsible for the information technology law practice, and we happen to have quite a substantial number of clients from the digital entertainment industry. And we see the growing recognition and the interest for the accessibility topic, and we also see that actually that topic is not that much covered at the events and the conferences, not only the gaming conferences, but generally. So we thought, and I convinced Aurelia, thank you for this opportunity and I'm very glad to be here as a speaker, definitely. And so I convinced Aurelia to have, a topic which will be devoted to the accessibility in gaming. It is quite interesting, and I hope you will enjoy it. So as a warm-up, I would like to start with, a couple of considerations. The reasons for which could explain why make video games accessible. And the first one is very typical for the lawyer. You may be that may be regulatory requirement, and you may be required to do so by law. So maybe you be required to make your service or product accessible. Very easy, blunt lawyer's perspective. The other one is more interesting, it may be the way of deepening the market, So actually you may make your customer base wider, bigger and stronger. So actually you could, generate additional turnover, and obviously also you can have an additional extra chance, for extra profit. The other are the reputational considerations. Actually, the perspective of the market matters, and the way you are perceived by the market actors has a very direct impact upon your business, definitely. So the nicer you are, the better the perspective. But it's not always about being nice, because accessibility is a part of a ESG, very hot topic currently, not only for the big companies who will be subject to the corporate sustainability reporting directive, and who will have a specific undertakings in that area, but also for the other smaller companies. And yeah, these are the four considerations around the accessibility issues. And then I will start with the first one, with the legal stuff. And at the beginning, very generally, and the legal framework, the UN Convention on the Rights of the Persons with Disabilities was adopted in 2006. It was a very ambitious act, a very ambitious treaty, and a landmark regulations, which has an ambition to set up, a global standard of accessibility for products and services. European Union joined in 2011, and then all member states ratified the convention, and the situation emerged where the European Union and all the member states have certain specific undertakings and obligation. For example, to develop information technologies, which are accessible per design to all the people with disabilities. So actually, we, as a result of this UN convention, all the member states are required to do some extra effort to introduce new laws in order to make the products and services more accessible on their markets. And that was recognized at the level of the European Union. And in order to avoid increasing disparities and disparities between the legislation of the given specific member states, there was an union action which resulted in the Web Accessibility Directive. And that is the directive which addressed the issue of the accessibility of the websites operated by the public entities. And then the next one, directive, that was the European Accessibility Act, which was adopted in 2019, and which is supposed to, and which is planned to, which will come into force next year by June 28. And then the last element is the soft law. Accessibility is becoming quite popular. There are a number of different codes of good practice, and the gaming companies are recognizing the relevance of that area, of that topic, and are happy to follow suit and to comply with a number of code of conducts, codes of good practices, and this is already happening. So the accessibility is becoming quite a big issue. So I'll start with the European Accessibility Act and the very fundamental question which was asked also today during other presentations, whether the video games can be patentable, whether video games can be subject to the European Accessibility Act. And I just realized during this conference that actually this question is not a right question to be asked really, because video games as such are very hard to grasp and to categorize. And we had this presentation of my colleague regarding the Nintendo judgment, actually, in which Court of Justice of the European Union said that the video game is a complex material. It's a very complex, very sophisticated product or service, hard to define, hard to categorize. And that question, does European Accessibility Act can apply to video games, is very hard to reply, due to the fact that actually it's very hard to say specifically what video games are. They may be treated as copyright works, definitely, potentially as audiovisual works. I mean, this is also disputable. There was a great dispute about categorization of video games as audiovisual media services. We know currently that actually this is rather not the case, but actually this is also an issue in the context of European Accessibility Act. And the basic concept of EAA is that actually it applies only to specific selected products and services. In principle, five broad categories of products and 6 services. I have elected those which appear to be more or less relevant to the gaming industry. And the first one is the consumer general purpose computer hardware system and the operating system for those hardware systems. So actually that could be relevant for the gaming industry from the perspective of the personal computers, because the very basic and the very core element of that product is the general computing capability. So it is a combination of a hardware which forms a computer which is capable of computing common computing task asked by the customers which are consumers, and which is designed for the consumers. So actually, the main element of that product, of the definition of that product, is its multi-function, multi-purpose capabilities, and they are definitely given with respect to the personal computers. So personal computers, which are one of the main devices to be used for the gaming, at least in Europe, definitely in Poland, will be subject to the accessibility requirement under the European Accessibility Act. But the next question is whether, for example, the game consoles will be subject to the accessibility requirements. And this is more tricky questions, because the game console, beyond any doubt, have some computing functions, computing skills, definitely, but it's also very obvious that actual game consoles are very much focused on the gaming. So actually this prerequisite of this multi-purpose computing is not fulfilled. So actually they will not be classified as a computer hardware system, I mean general purpose computer hardware system. So actually most likely they will not be subject to the accessibility requirements. They could be, I mean, the game console could be regarded as a consumer terminal equipment with interactive computing capability, used either for electronic communication services or for accessing audiovisual media services. We see that actually the modern consoles are more capable. I mean, they are used not only for the gaming, but also for the media consumption. But nevertheless, I mean, a lot of streaming, also for the communication between the gamers, but not only, also beyond the games and beyond gaming business. But nevertheless, I mean, again, the definition of the consumer terminal equipment used for the accessing audiovisual media services is that actually it should be any equipment, the main purpose of which is to grant or to ensure the access to the audio-visual media services. I mean, of course, this can happen with respect to the game consoles. They can be used in that way, but it is also quite obvious that actually they will be using mainly for the gaming, and that the main purpose of game consoles will not be accessing, the audio-visual media services, but again, gaming, which means that actually game consoles will not be required to comply with the accessibility requirements. But what is more relevant for the gaming industry are the services which will have to comply with the accessibility requirements and which consequently would have to be accessible. It is the electronic communication services, e-commerce services, and services providing access to audiovisual media services. And for all the gaming development companies, the e-commerce services, it means that actually all the digital video distribution platforms would have to be accessible. I mean, the European Accessibility Act, or better to say, all the national implementation of EAA will apply to the e-commerce services. In terms of the gaming, that will be this distribution platform, digital distribution platform, but also, like, so for example, GOG, Steam, Epic Games, Origin, and others. There are many others, actually you can name them. But also the in-game purchases. If you look at the in-game purchases and what happens during the gameplay, during the game, they could also qualify as e-commerce services from the perspective of EAA. So actually the accessibility requirements will very directly apply to the video games, not as such, not as the video games as such, but to some of its functionalities and some of its elements. Yeah, and there is, a further slide regarding the substantive scope of application of European Accessibility Act regarding the electronic communication service. The question is whether for example, the communication channel in a video game would have to be made accessible, and whether it will be a legal requirement from the perspective of the European Accessibility Act to make such video channel accessible. And then one of the services which is subject to EAA is the electronic communication service, and I provided the definition of it. I mean, the definition is not in the EAA Act as such, but it's referred to the European Electronic Communication Codes, and you can see the definition on the screen. Sorry for this, I understand we are mostly lawyers, so no harm, no bones broken. And if you look at the definition, actually all the elements, that it is an interpersonal communication service normally provided for remuneration that enables direct interpersonal interactive exchange information, and so on and so on. So all the elements are fulfilled, if you look at the video gaming channel. But then you've got this caveat at the end, that actually there is some caveat narrowing down the definition, that actually interpersonal communication service does not include services which enable interpersonal and interactive communication merely as a minor ancillary feature that is intrinsically linked to another service. And the question is whether that would be the case for the communication channel in a video game, And the answer is that usually communication channel in a video game will not be required to be accessible under the EAA, provided, of course, it depends on the circumstances, provided, of course, that this is not the core or the main element or the substantial element of the gameplay. So you can imagine a game where the communication between the players is not that relevant, maybe helpful, maybe something extra which makes the game more interesting, more social, more immersive, why not? But there is a number of games in which the communication between the players has a very direct impact on the outcome of the gameplay and also on the game as such. And you could consider such examples like Fortnite, a very well-known game, without the communication between the players. I mean, the communication between the players can definitely impact the outcome of the fight, of the battle which is being fought between the players. And the question is this something additional only to the game as such, which we can perceive separately, or is it something which is, one of the core, maybe not the core elements, but the very important elements of the game as such? If we would say yes, that actually this is one of the main elements of the game as such, then actually the accessibility requirements will apply also to this communication channel. And the issue, which the reason why I'm addressing this issue is actually there are some interpretation guidelines included in the recitals, and in respect to that particular definition, these are the recitals in the European Electronic Communication Code, which are very helpful in terms of understanding, the provisions of the given directive. And also, this is the case here. And in these recitals, the communication channel was expressly excluded. This was provided as an example, which could demonstrate that actually such communication channels should not fall within the scope of the definition of interpersonal communication service, but again, with a caveat that should be very exceptional, that should include such situation in which this communication is, from the perspective of the gamer, not that relevant, and its use for the gamers is very limited, which again, that is the other argument. And with respect to many games, this is not the case. I mean, with respect to the many games like, I don't know, Fortnite, Counter-Strike, all the typical, fighting games, where you do this cooperative coordination between the teams, such communication channels are quite substantial, and they could be, perceived definitely as interpersonal communication service, which needs to be accessible under the European Accessibility Act. And I have also provided some examples of the selected accessibility requirements. So the conclusion would be that to some extent, the accessibility requirements will apply to some elements of the games, but not to the games as such. And here you have some examples, of what it really means. I mean, what is really required from the service providers and manufacturers. And in terms of the provision, and this is, quite simple. I mean, you've got, a couple of annexes to the directive. In one of the annexes, you've got the actual requirements. I mean, it is provided what has to be done. And the further annex serves with the list of the non-binding indicative examples. So actually, the European legislator is quite, I would say, forthcoming, and is upfront, providing the examples how the requirements may be complied with. And in terms of the provision of information, it's quite simple. Information should be available via more than one sensory channel. So that's the example of the accessibility requirement. I mean, the accessibility requirement as such. And then you've got the example in the other annex to the directive that providing electronic files which can be read by the computer using screen readers so that the blind person can use the information is the example of complying with that given requirements. Fonts should be of adequate size, suitable shape, using sufficient contrast. Of course, alternative presentation of any non-textual information. So if you are using a diagram with if you are using a diagram, then you should also add a text description identifying the main elements of describing the key action. You've got also additional requirements for specific services, and again, that will be very relevant for the e-commerce services. I mean, for the gaming industry, as regards the e-commerce services, ensuring the accessibility of the functionality for the identification, security, and payment by making it perceivable, operable, understandable, and robust. If you look at this accessibility requirement as such, it's a very broad, very general guideline. You have no idea what is really required from you, but then by using the example, you may get some further clues as to what what is mandatory and what should be made by the service providers or by the manufacturers, by the producers, making the payment service user interface available by voice so that the blind persons can make online purchase independently. And then continuation of the accessibility requirements. These are the examples of the accessibility requirements with respect to the products. This will be less relevant for the gaming industry, so maybe will not discuss this in a big detail, really. And compliance with the harmonized standards. The other concept of the European Accessibility Act is actually you can reach the compliance by complying with the harmonized standard. And they set out the technical specification of the accessibility requirements. So they make them even more specific. And if you have some doubts as to what should be done to make your product or your service compliance, then you can also always refer to the harmonized standards. Of course, not any, because the European Accessibility Directive provides for a presumption that once you comply with the harmonized standard, you comply with the accessibility requirement as such. Of course, it doesn't apply to every harmonized standard. It has to be the European harmonized standards, which was referenced in the Journal of Law of European Union. So actually, it is only about the European standards. And there will be further standardization effort. I mean, the Commission started already the procedure of creating three additional harmonization standards, and the three others will be updated. So actually, there will be kind of substantial support for all the service providers and producers who need to comply with the accessibility requirements. And luckily, there will be some exceptions from accessibility requirements. First of all, the micro enterprises who provide services will not have to comply. I mean, they are exempted, and it means that actually most of the indie game developers will not be required to comply with accessibility requirements. They are encouraged to do so, but it's not a must. And then the other example, a very broad one, the accessibility requirements apply only to the extent that compliance does not require significant change in a product or service that results in a fundamental alteration of its basic nature or does not result in the imposition of disproportionate burden. And this is, an exception which may apply to anyone, but it's quite interesting because it's not the question whether the accessibility standard will apply or not, but rather to what extent. So actually, kind of a tricky exception if a company elects to rely on the exception, it has to do appropriate assessment of the criteria. It has to document this assessment because it may be required by the authorities to demonstrate that actually the exception is applicable in fact. And there are certain specific conditions which needs to be complied with respect to in the context of this exception. For example, funding. If a company, a game development company for indie developers, for example, who is dealing with products, is using funding which comes either from the public bodies or the private companies, and the purpose of the funding is to also to improve the accessibility of the products or services, then actually that company cannot rely on the second precondition, on the second element, imposition of the disproportionate burden. So it's quite relevant at the stage where you are, when you are getting the funding. It is a quite crucial decision, and also the need for big awareness whether you would like to rely on the exception or not. Because if yes, and that exception should be based on the disproportionate burden, it is vital to make sure that actually this funding which is acquired is not stipulated and agreed as a funding to improve the accessibility, because that may decrease the chances of using that exception. And very quickly, obligation of economic operators. I mean, the European Accessibility Act uses this concept of economic operators, but it is about the service providers, manufacturers, distributors, and importers. So I presented the list of obligations of the service providers because this is more relevant for the gaming company. So they need to design and provide services in accordance with the accessibility requirements, of course. There is a requirement to publish, the information on accessibility of services. I mean, the service provider needs to explain, how the product was made accessible, and that should be the part of the terms and conditions, or EULAs, or terms of service, however it is called. I mean, that should be addressed in the legal document. A compliance procedure should be in place. Of course, the service is changing. Accessibility requirements may also change. And interestingly enough, also the harmonized standards may evolve and may change in the future. Once it happens, there should be a compliance procedure in place, and the service provider should react accordingly to keep the service compliant despite the changes which happened. Of course, the corrective measures needs to be taken in case of non-compliance, and cooperation with the authorities. The obligations of the other economic operators, so manufacturers, importers, distributors, are a little bit different, similar but different. Except for the corrective measure, there can be withdrawal of the product from the market. Manufacturers needs to carry out an assessment of the accessibility of the products, and this assessment has to also be documented and must be presented to the authorities at their request. And quick look at the market surveillance system in Poland. It is quite interesting because we can harmonize the laws at the level of the directive, but then the enforcement is subject to the national particularities, and this is how it will look like in Poland. So the overview of the system of the authorities. So the main authority will be board, president of the State Fund for the Rehabilitation of Persons with Disabilities. Very interesting name, very long one. And this is, currently the main body, the main entity dealing with the issues of persons with disabilities in Poland. And this will be the body who will be coordinating and monitoring the whole system, because the very market surveillance authorities will be different bodies, and it will very much depend on the given product or the service. So for the products and services which are potentially interesting for the gaming industry, it will be the president of the Office for the Electronic Communication, and you can see the list of the products which will be supervised by this authority. So, for example, it is general purpose computer hardware, systems, interpersonal communication services, but also e-book readers. And the other one, for example, is the Minister of Digitalization, who will be supervising the accessibility with respect to the e-commerce services, which that could be the authority quite relevant for the gaming industry in Poland. And interestingly, this is also quite peculiar, I would say, for the Polish system. The custom authorities, they will be supervising the accessibility with respect to the goods which are being imported, products which are being imported onto the Polish market. And measures. So what is the risk? What is the risk of being non-compliant? I mean, the authorities will have the typical inspection rights. So each company can be inspected. And the authorities may request expert opinions, arrange sample tests, can secure evidence. Interestingly enough, the sample test will be made at the cost of the inspected company, unless the sample test confirms that actually the product is compliant and is accessible in accordance with the Polish implementation of the European Accessibility Act. During the inspection, but also later on, the authorities may order the inspected companies to carry out the assessment with respect to this exception, which I already discussed. So actually, there may be a situation that the company did not make any assessment as to whether they can rely on the exception. Or, for example, the authorities may come to the conclusion that the criteria used for this assessment were wrong, and the assessment has to be repeated. And then what can be ordered? Corrective action, product withdrawal, discontinuation of the service. That can really hard. That can be very risky and burdensome for the service providers. And companies may be ordered to notify the consumer of non-conformity. There will be option of fines. The fines will be not staggering and not overwhelming. You can see this figure, but it serves only as a sort of an orientation, because the figure is defined, as a 10 times of the average remuneration from the previous year. So, the 70,000 euro is more or less 10 times the average remuneration in the Polish economy in 2023. So once the Polish implementation of European Accessibility Act will start to apply in 2025, it will be a bit higher amount because it will be based on the average remuneration in 2024. And there is an additional cap, no more than 10% of the turnover. So not very painful, but it is quite apparent and obvious that actually it's not about the fines. It is also about the fines, but what can be really dangerous, for the business and harmful, it is these, corrective actions and the ban on the product or ban on the service, So the service can be eventually stopped, for being sold, which can be, of course, a disaster for any business, and also the PR impact. So actually, the notification to the consumer may be very harmful in terms of the goodwill of the company. And then the consumer actions, consumer compliant, and the consumer notification to the authorities. One maybe additional remark about the consumer compliant. I will need to do that on my own and check how it works in practice in 2025, because it's quite interesting concept. The consumer may comply to the service provider or to the manufacturer and can say, look, your product or your service does not comply with the accessibility requirements, and I believe it should be made accessible in this and this way. So the consumer can suggest, the way how the service of the product should be made compliant. And then you need to be very careful. You've got deadlines. So actually, you've got 30 days to respond the consumer compliant. You have option to extend that deadline up to 60 days, But if you don't reply, either by first deadline or the second deadline, then the consumer compliant is deemed acknowledged, and you are obliged to implement the consumer suggestion. So this is what I'm planning for 2025. I will write a consumer compliant to a client of our competitor. That will be a favor, to our colleagues, so maybe not. But that will be interesting, and that's something I need to consider in 2025. So you can write the compliant, you can suggest something, and if the company is not careful enough, they will be obliged to implement your proposal. So very, very interesting system, and I'm curious, how it will work in practice. Okay, in the timeline, the European Accessibility Act was adopted in 2019. It should apply by 28 June 2025. There will be some transitional term periods, for the service contract. So actually, the service contract which are not compliant with the new implementation provisions may continue to apply. This is a very practical question for the service providers, including, definitely the gaming sector, whether you would like to continue with different types of the agreements with the gamers, with your customer. It would be much better from the practical perspective to adopt all the contracts. Using the current, meaning both the current gamers, current customers, as well as the new ones. But there is an option of continuing with the agreement which is not updated, and there is also an option for the service providers to use the products while providing services which are not compliant with the accessibility requirements. There is also an extra transition period, optional, for the member states, and the Poland did for the option, but that applies to the self terminals, so which is not that relevant to the gaming. And now, this is quite interesting and relevant for the gaming industry, because it transpires that actually the European Accessibility Act will not be that relevant really for the gaming industry, except for the e-commerce services. I mean, personal computers, but it is not really the gaming industry. The personal computers are not being produced by the gaming companies, but but other companies. Maybe the question whether the game consoles, this is quite interesting. I would bet that actually the game console should not be subject to the requirements, but you never know in which direction the authorities would go in every country. So actually, but I think it's very unlikely that the game consoles should be subject to the accessibility requirements. But then you see this trend on the market, and it's quite apparent and clear that actually the gaming companies are happy and are willing, maybe even eager, to make the games accessible, even though they are not required to do so. And they are following good practice codes. There are many guidelines which are available on the market, and many gaming companies are already, providing information that they do comply, they would like to be, and it's, very positive approach, really, It's about the values, not only about the business, not only about being nice to make more money, but simply to be socially responsible and to make the games accessible for the broader audience. And this is, nothing bad about this, quite the opposite. It's a very good direction. But then it can be very tricky. I mean, at least in Poland, because I'll be now talking mostly based on the Polish background, I mean, Polish experience and Polish legal system, because the accessibility will inevitably interfere with the video games features. And the fact is that actually, let's imagine such a situation that a gaming company would like to make the game accessible, which will mean that the gaming company would have to change the terms and conditions, so OILA, terms of service, maybe also other legal documents, and it is very hard, at least in Poland, to change the contract with a consumer, and it's very easy to do that in proper way, which is not compliant with the consumer protection laws in Poland. And there is additional element, behind this, is that actually there is another authority, the Consumer Protection Authority. In Poland is the president of the Office for the Protection of Competition and Consumers, which is not the market surveillance, which will not be the market surveillance authority for the accessibility requirements. It will be a bit different authorities. So on one hand, you will have this Polish act implementing European Accessibility Directive, and the general encouragement to follow suit and to make the game accessible, even though it's not required by law. But on the other hand, you will have this quite stringent, I would say, sometimes very aggressive, maybe not aggressive, but fairly aggressive, sometimes Polish authority with respect to the consumer protection, which has a totally different perspective, So changing the game, changing the terms and conditions without good reason. Such a good reason would be to make the game compliant with the legal requirements. But again, that would not be the case in this situation, That would be something extra to make the game simply more accessible, but something which goes clearly beyond what is legal requirement. And this, touches upon one issue which is quite relevant for the consumer protection in Poland. And actually, if you have general terms and conditions of a service, of a digital service, such as a game, for example, then you need to have the modification clause. And this modification clause has to be drafted and regulated very detailed and specifically, and it needs to set, all these situations, very specific and detailed situation, when the contract with consumer may be changed, And the question whether it can be changed because of the company would like to make the service more accessible would be quite disputable from the perspective of the Polish Consumer Protection Authority. So you see this clash of bit different interests, and it may not be that easy, at least in Poland, to voluntarily make the game accessible for the consumers. the gamers. So conclusions, I mean a short recap, which products and services must comply. Video games as such, I mean, as I mentioned, I mean, it's hard to say what video games are, really. I think that perspective is very tricky. I mean, it's a combination of very different elements, but there is no such obligation. Video games as such do not have to be accessible. Personal computers, definitely. Game consoles, rather not. E-commerce service, definitely, so very relevant for the gaming industry. Digital platforms digital distribution platforms for video games, but also in-game purchases function that will be subject to the European Accessibility Act and would have to be compliant. Communication channel in the video games, that will depend on the circumstances. I would say many communication channels could be that relevant that they will be subject to the accessibility requirements. I wouldn't be surprised about this. Voluntary accessibility is recommended, but may be tricky, at least in Poland. Be careful. And of course, as always, that's simply quite trivial, but always important. Better be prepared and alert. I mean, the national implementations will apply from June 2025. There's not that much time left. It is a good time to start preparation for the compliance with the national transposition of the European Accessibility Act. Yeah, thank you for attention. And if there are any questions, I would be happy to address them.
Thank you so much. That was really insightful. And do we have any questions from the audience?
Oh, come on, I asked so many questions, at the previous presentation, so I deserve at least one question.
I can ask this one question. If you are voluntarily willing to comply with the requirement, you are not then under the regulation, right? It's only the code of conduct or just being compliant as such. There is no stepping in and not being able to step back. You would not be obliged by law, but only by some certain codes.
Yeah.
If you would declare to the public, what I mean, if you would declare to the public that you want the game or any other product to be accessible to people with disabilities, and then are you be able to discontinue that action?
Yeah, it will not be easy. I realize that may differ from country to country. I mean, the European Union country. In Poland, it would be very difficult because that would mean most likely that you would need to change the terms and conditions. You would need to have this very, very tricky modification clause. So you need to consider whether the modification clause in your general terms and conditions, in your OILAs, cover the situation. If so, then you consider this change. But again, that will be verified by the Polish Consumer Protection Authority, and that could be in compliance with the consumer protection legislation in Poland. So it would be very tricky, and in many situations it would not be possible. So you can make your, I think first you can make the game accessible. That will be quite challenging, but then going back would be even more challenging than to make it accessible. And there is maybe an additional element that actually, if you are openly saying that you are complying with the code of conduct of good practices or whatever, this can be if this code of conduct includes a set of guidelines which are specific enough to be verified. If you do not comply, this can be treated as a misleading consumer practice across, in every EU member state, and this can also be an additional issue. So it's a very tricky thing to do what you are not required to do by law, at least in Poland, and it's not that easy, even if this is about accessibility and a social responsible approach. So
thank you again.